Alhamdulillah, wassalatu wassalam ala rasulillah. All praise is due to Allah, and may Allah's peace and blessings be on the last messenger of Allah. In the previous session, we covered the third stage, which is the stage of building, or the stage, we could say, of the Umayyad dynasty, which was basically about 100 years. And that dynasty began with Caliph Muawiyah ibn Abi Sufyan, and continued till the last of his descendants were overthrown by the Abbasid family, and the new dynasty was set up in the middle of the 8th century. This dynasty functioned or continued for a number of hundreds of years, but what we're looking at when we talk about the fourth stage, or the stage of flowering, it is basically the first 200 years of that period. The first 100 years of it is considered to be the period of the great Imams, and the latter 100 is that of their students and their students. So those people who have worked on the history of the evolution of fiqh, etc., have divided it into these particular periods. So what we're looking at basically in this stage is the period in which fiqh is consolidated and after flowering, and then beginning to decline. Now, if we look at the development of fiqh in this period here, we can see in the early section, the section which is that of the great Imams, that the general principle of flexibility that was held by the generation of the Sahaba and those who came after them, the Tabi'een, remained. The scholars were free about studying under whomsoever they wished, changing rulings whenever evidence came to them, etc. But towards the end of this period, after the death of the leading scholars, the great Imams, what we find then is a period in which certain rigidity begins. So if we go back and start to look at the period of the great Imams, the first 100 years from 750 to 850 of the Christian era, we see certain factors which encouraged the flowering of fiqh during this era. The first factor is that of state support for scholars. This is the actual opposite of what had happened in the Umayyad period. During the Umayyad period, as the state drifted away from the prophetic way, and we found with them innovations, etc., the scholars fled from around the caliphs. So the link that we saw in the early generation, at the time of the Sahaba, the righteous caliphs, etc., between the fiqh and the caliphate, that link was broken. The scholars scattered, went away from the court to the outer lying areas of the Muslim state, avoiding being drawn into situations where they would be forced to make rulings, which go against their own positions, etc. So what you find is that with the beginning of the Abbasid era, which is started by Caliph Abu al-Abbas, who is from, the uncles of the Prophet ﷺ, Al-Abbas's descendants, they gained the caliphate on a call to a return to Sharia and the legitimate interpretation and implementation of the Sharia. That was their call. That's what people rallied around. Even in this period, they took the black flag as their symbol, the black turban of the Prophet ﷺ. This was, so they were trying to identify with the prophethood and the Sharia and this, so they came in with that call. They even brought in the Alids, the people from the family of Ali, and those who were around them, some of those who were around them, they promised them, positions and to bring, Ali's descendants back to be the caliphs. And the promises like this were made at different points and broken. But, the point is that initially, this is their call for support, to overthrow the Umayyads. So naturally, once they came in on that note, then it's not surprising that they invited the scholars into their inner circle and encourage, and they used to put their children to study under the scholars, right? So you even found among them one of the leading caliphs of the early period, the Caliph Harun al-Rashid, who ruled for some 23 years. He had one of the longest rules, because the founder only ruled for about 4 years himself, Abu al-Abbas. But Harun al-Rashid ruled for some 23 years, and he was himself a scholar of Islamic law. He was a faqih. So it is not surprising because of the support that was given, as I said, to scholarship. And naturally, that's going to lead to a flowering of fiqh, because fiqh is now elevated, given a high status, favor is there. So these are factors which are going to lead to the development, the strengthening of the fiqh. In this period, you had, for example, Imam Malik was invited by Caliph al-Mansur to compile, a compendium of Islamic law based on the hadiths. So that's what he did, al-Muwatta. That was what it is, the well-beaten path. He compiled this. And after he compiled it and gave it to the Caliph for benefit, then the Caliph asked his permission to implement it as the law of the Muslim state, the empire. But Imam Malik refused. He said no. He didn't agree because he knew that what he compiled was based on the fiqh of Hijaz, al-Hijaz, where he was. He didn't travel. He didn't travel to outside of Medina except for Hajj. He went to Mecca. Otherwise, he was born, he lived, he didn't travel from Medina. Medina was filled with all kinds of knowledge, etc. It really didn't need to go anywhere. So he didn't agree, because he knew that there were other elements of the Sunnah which other scholars had gathered. He had been in debates and discussions with them by letters, and students of theirs coming and discussing with him. So he was well aware that there were hadiths which he hadn't compiled, which were compiled by other scholars, etc. So that it wouldn't be wise to make a single madhab, that of the binding on all Muslims, but the flexibility should be there for the leadership to have scholars around them and draw from the information that's available. Of course, though on one hand we had this strong court support and invitation of scholars, we did have some of the caliphs among them, who were very reactionary if the scholars ruled against any of their positions. So you found at the same time, though on one hand, one caliph invited Imam Malik to put a legal system for the Ummah. Another caliph, when Imam Malik ruled against their practice of making people give allegiance on the basis that if they break allegiance, they are automatically divorced. When Imam Malik was presented this issue, he ruled that such a condition that they've made, such an oath they've made, is in null and void, because it goes against the actual teaching of Prophet Muhammad sallallahu alaihi wasallam. So where we have such a contradiction, where the rules of the Prophet sallallahu alaihi wasallam are openly broken, then in terms of oaths, then such oaths are not binding. A person may still have to expiate it, that's another issue, right? Then again, if it's under duress, then expiation is excused, and so etc. But anyway, the point is that when he made this ruling, he was jailed and tortured. right? So you had some of this and some of that. But in general, there was state support for the scholars. The second major factor, we could say, is that of an increase in the centers of learning. Naturally, with state support, then, scholars establishing themselves and being in major centers, being supported by the state, students being supported, encouraged to study, etc. Naturally, you're going to have a number of centers of learning, developing. And also, we found in this period that although the Umayyad dynasty was destroyed in the east, one of the descendants, Abdurrahman ibn Muawiyah, he escaped the massacre which took place in Baghdad and made it across North Africa to Spain, and he was established there as the Caliph. So the Umayyad dynasty continued in Spain. So what you had for a stretch of time was two caliphs. The Caliph in Spain for the Umayyad dynasty and the Caliph in Baghdad. And in Baghdad, of course, there was no attempt to try to take on the situation in Spain because it was too far away, and it didn't affect their rule really. So naturally, Spain became one of the centers of learning, and scholarship spread there too. The Zahiri madhab of Dawood al-Zahiri, who was one of the students of Ahmad ibn Hanbal, was revived there in Spain by Ibn Rushd, one of the leading scholars of that era. Anyway, so that became a center of learning, of fiqh, and all throughout the Muslim realm, we find in all the major cities scholars and circles, and the students of these scholars began the process of traveling. There's an encouragement now to travel all over the realm. So you find this is the period of the journeying of the scholars, right? This is noted in that period. So Muhammad ibn al-Hasan al-Shaybani, the student of Abu Hanifa, he travels to Medina and studies under Imam Malik. Studies and memorizes the Muwatta of Imam Malik and becomes one of the narrators of the Muwatta. Imam Shafi'i, student of Imam Malik, travels to Iraq. He travels to Egypt, combines the fiqh of Hijaz, where he studied under Imam Malik first, and then the fiqh of Iraq, along with the fiqh of Egypt, and develops his own approach, right? So you find many, many examples of scholars traveling during this period, the students of the scholars. So naturally, this is sort of what we could call cross-fertilization of knowledge, right? People of one area, bringing the knowledge of the area into another, sharing, discussion, debates. So what you found in this period also, there's a spread of debate and discussion where the scholars are engaged in various debates, working out issues which they disagreed with each other. For example, Imam al-Layth disagreed with Imam Malik's position of including the opinion or the practice of the Madinites as a source of Islamic law. Imam Malik included the practice of the Madinites. Imam al-Layth rejected it, and they had a debate by letters, for a number of years. As a result of certain discussions and debates like this between the scholars themselves and their students, what you find is that certain issues which had become known in particular areas were corrected, where there are errors in them. The scholars came to mutual conclusions or acceptance of differences or different approaches. And you found a lot of changes because, as I mentioned, the students of Abu Hanifa, for example, came and studied under Imam Malik, and they came back to Iraq and changed a number of rulings. Because in Iraq, as you mentioned earlier, the attitude was, not very favorable for hadith narrations because of the fact that fabrication of hadiths was developing there. So people were wary about hadith narrations. And in fact, if they deduced fiqh principles and later on a hadith pops up which goes against those principles, they oftentimes would reject the hadith on the basis of the principle. That if the principle, they would prefer the principle over the hadith. Unless that hadith was so well known and so sound, then they would have to change the position of the principle. But otherwise, if it was just a hadith, which was authentic but not well known, then they would not give it precedence over the principles that they evolved. So, for example, Imam Abu Hanifa, in his time, because of the fact that the literal meaning of khamr was alcohol produced from grapes. Alcohol produced from grapes. He took the position that is what is automatically prohibited. Alcohol produced from grapes. Otherwise, any other alcohol produced from any other sources would be permissible as long as you weren't intoxicated by it. Whereas alcohol from grapes, prohibited across the board. That was the position that he took. Right? His students, all three of his students, Zufar, Abu Yusuf, and Muhammad ibn al-Hasan, all of them, after they gained the knowledge from Medina and elsewhere, they rejected that ruling and corrected it in the school and accepted that anything which intoxicated would be classified as khamr. That would be the basic ruling. As Umar ibn al-Khattab had said, he had given a definition for khamr, saying, al-khamr ma yukhamir al-aql. Khamr is what veils the mind. So khamr, which means a veil, because this is the woman's khimar, what she wears is a veil, right? It veils the hair, covers, etc. So similarly, the alcohol was called khamr because of the fact that it veils the mind. So whatever veils the mind would be considered as khamr. That would be the ruling, right? So it didn't have to be restricted only to liquids. And actually, the people in Medina, they didn't make khamr from grapes. They were known to make it from dates. Right? Their alcohol was from dates. And this is when the law prohibiting it in its final form came. In Mecca they did have grapes, etc., but in Medina they didn't. So the point is that was actually enough evidence to show that it shouldn't be restricted to its linguistic meaning. Anyway, we find that's just an example of a change in the rulings. And as scholars have pointed out, in the time of Muhammad ibn al-Hasan and Abu Yusuf, more than 50% of the rulings of Abu Hanifa were overturned. More than 50%. So it means then, that's why we say the madhab, the Hanafi madhab, cannot really be attributed to Abu Hanifa. Some of it is, but most of it isn't. Now, during the period after the death of the leading imams, we find a change, right? We said that a tendency towards rigidity started to develop. And the quality of the fiqh in that era now, this is the next 100 years, we find it changing. There's a qualitative change. What are the factors behind it? Well, first and foremost, you had the compilation of fiqh. In this era, we find the fiqh of the various schools, etc., are being compiled, reduced to writing. We find also that the hadiths were also systematically compiled. Now, the compilation of the hadith was actually a good supportive development which encouraged further flowering, and this is in the earlier part of the second hundred, right? Because what it did is that it gave the scholars of law more opportunity to work on the deduction and comprehension of the narrations. In the earlier period, in the time of Abu Hanifa and the others, those scholars had to themselves travel. Imam Ahmed, Shafi'i, etc., had to travel to get the knowledge. They had to travel to compile hadiths. They themselves wrote compilations of hadith, you know. So part of the time was spent in evolving and developing the fiqh, but a good part of the time was spent in just finding the hadiths. So now when all the hadiths are now compiled for you, then you've got more opportunity to work on them, to develop the principles, etc. So you find that period, in the early part of it, there was an element of flowering in that regard. But at the same time, as we find the scholars of that era compiling their writings and their students, really. In the case of Abu Hanifa, he didn't compile any writings. Imam Malik compiled the hadith compilation Al-Muwatta, which contained also fiqh rulings, opinions of the Sahaba, etc., etc. But once we go to Shafi'i, we find Shafi'i actually compiling. Ahmed ibn Hanbal, he didn't compile for himself, his son compiled and students compiled, right? Imam Malik's students actually compiled the madhab. Imam Malik compiled hadith and opinions and rulings for his students, but they compile what we know now as the madhab, right? And that's why you'll find, differences between what Imam Malik compiled and what his students compiled, right? So when we look at the compilations, we see them coming in a set of different forms, basically three main forms. The first form was a mixture of hadiths, opinions of the Sahaba, and the students of the Sahaba, along with the legal rulings of the scholars themselves. The example of that is Al-Muwatta. It's a classical example. We have a copy in the library of it. You can have a look at it, read it, just to get a feel for the difference between it and, say, books of hadith like Bukhari or Muslim, In the second period, we find there's some evolution in terms of the writings. We find now scholars writing the principles of fiqh. In fact, Imam Shafi'i, in his text called Ar-Risala, he basically laid down the principles of fiqh. He is considered the father of fiqh, of usul al-fiqh and fiqh principles. So his writings, when you look at his compilation of his rulings, of his opinions, etc., you'll find the fiqh element of it a lot stronger, right? And the hadiths are brought to prove positions of fiqh. Whereas Imam Malik's time, hadiths were brought to derive rulings of fiqh. His compilation was to aid in the derivation of rulings, right? And also you find Imam Abu Yusuf, he had a book called Al-Kharaj, Kitab al-Kharaj. His is similar in its format to Al of Imam Shafi'i. The third stage, we find books of fiqh which are focusing on the application of the fiqh principles. Now these books tended to be organized according to masail, issues that arose. So the book would concern itself with the issues, bringing hadiths only where necessary to clarify positions on the various issues. Rulings of the madhab may dominate, and you find the use of hadiths is less, and the classical text called Al-Mudawwan by Imam Ibn al-Qasim, student of Imam Malik, right, Ibn Anas. His text, Al-Mudawwana, is a classical example of such a text. And what we find is that in the text of that latter period, or like Mudawwana, etc., is that though initially when they compiled the various issues and the rulings concerning them and the hadiths related to them, they used to mention the hadiths along with their isnad. The full isnad was there. Later on, they dropped the isnad and would just mention the books from which they were found. And then later on, even the books were dropped. And, the hadiths became used less and less, and the position of the madhab started to dominate. So you find books being written without even any mention of hadiths, very rarely. You found because the opinion of the madhab now had taken on or was given precedence over your primary source of the sunnah. Now, in this period, the period of the minor scholars, now the state love of hadith and the scholarship and promotion of scholarship on a high level has dwindled. Now you're coming to a period which is similar to that of the Umayyads, right? The quality of the court is changing, Now you find in the court of this latter period a court scholar. You'd have court scholars there, right? As well as magicians. You would find singers, dancing girls, jesters, right, to make the court laugh. And astrologers. You also had your court astrologer, to predict for the caliph, when next to do battle or whatever. So you see the quality of the court now had changed. His entourage was for his entertainment. He has his close friends, etc., who would be entertained. So what happened is that the scholars, he would have scholars there, court scholars, who would be willing to come, and they would debate fiqh issues for the entertainment, the intellectual entertainment of the caliph and his entourage, right? So what happened is that, naturally, after some years of doing this, the fiqh, which was practical fiqh, ran out. And hypothetical fiqh, which was initially looked at by the scholars, especially in Iraq, etc., for the purpose of looking at real issues which could develop and how to deal with these issues. These were used up. So what you found now developing is another brand or another chapter in hypothetical fiqh, which was, you could say, hypothetical fiqh which reached the absurd. So you find in the books written in this period rulings about things which shouldn't have been made. I ran into a book which was translated from that era in Singapore, and it was a book on, supposedly, primary book on Islam for new Muslims they were distributing. I started to look through this thing and I realized that this book was from that era. And when they were talking about issues of the fiqh, wudu and things related to wudu and stuff, you found things in there which would make you cry. There were issues discussing whether a person's wudu would be broken if he had sexual relations with a fish. If non-Muslims were to come across such a book, this would just be such an embarrassment for Muslims. I told the brothers in Singapore, please burn this book. Get rid of this book. Do not distribute it to anybody. They think Muslims are mad, So this book was filled with such rulings. Furthermore, similar books, that's from the Hanafi school. I was listening to one scholar speaking about such similar rulings from the Shafi'i school, and you can find it from all of the schools, ruling similar. In the Shafi'i school, they were describing a ruling concerning a person if he passed wind into a bag, right, and then closed the bag, made wudu, then opened the bag and let the wind out, would his wudu be broken? Would he have to repeat his wudu? This is what we call fiqh of the absurd, right? So, it is, we can laugh about it now, but it was a product of the court debates. As I said, where they ran out of practical fiqh, and they had to now invent issues. And what would happen is that there would be a faqih from the Hanafi school and the Shafi'i school, because these became the two dominant schools at the time, Hanafi and Shafi'i. And some issue would be raised, and they would debate it for the entertainment of the caliph. And so what happened along with this is that people, because whoever won the debate would be given, a bag of gold, right? A little bag of, prize, right? Reward for having won the debate. So what that spawned then was, a fanaticism for the madhab. Because, if you lost the debate, you lost the prize. Also, you lost face, right? You lost face. And when you lost face for your madhab. So then the idea of what we call my madhab, right or wrong, developed. Where people would argue, even knowing full well that the position of the madhab is wrong, they would still fight for it in defense of it. They would go down in flames, clinging to it desperately. So this is where you can see naturally from that, a rigidity about the madhabs naturally is going to come from that, right? Also, in this period, as we mentioned, the hadiths were compiled, and this compilation of hadith, you could say, was a reverse trend against what was happening in the court debates. Because here were now scholars. Though we call them scholars of hadith, they were scholars. Imam Bukhari, Imam Muslim, Abu Dawud, Tirmidhi, these were scholars. We call them hadith scholars, but they were scholars, Islamic scholars, scholars of fiqh, everything was there with them. But what they did was they were compiling the evidences. They were taking fiqh back to its sources. So they represented the counter trend. And from them, you had scholars who followed that tradition of what we call Ahlul Hadith. So they're scholars, even though they may have been trained in a particular madhab, etc., but they would study the hadiths, and that would be the deciding factor for them, which was, of course, the way of the early generation. And we could say that probably the initiator of this trend was Imam Ahmad ibn Hanbal himself, who made the largest compilation of hadiths, his Musnad, containing more than 40,000 hadiths. The fourth factor affecting the fiqh of this era was the organization of fiqh. As the Islamic realm now began the process of absorbing the knowledge of the various civilizations which it had conquered, and learning scholars, etc., were brought to the centers for discussion, etc. Greece, Rome, Persia, India, with their tradition of philosophy and reasoning and scholarship, etc., their knowledge was absorbed. Baytul Hikmah had been set up in Baghdad for the translation of classics from Greece and Rome, etc. So what happened is that new approaches to reasoning and deduction arose. Actually, some scholars from the Ahli Hadith trend, or you could say approach, they look down on this trend because Greek reasoning and logic took over fiqh. And what it did was it provided a means of argumentation in those court debates, so you could never pin the scholar down. There was always a loophole how to get out, so you won't lose your debate. You found what it did, it provided ways, because this is what the early writers of logic etc. from Greece and that, I mean, this was, intellectual, entertainment. So this approach did, in a sense, taint and corrupt the development of usul fiqh. And the books of that period, when you try to read some of them, they're filled with Greek logic. I mean, you can't, it's like puzzles, the expressions that were used, could hardly understand them. Anyway, during this period, fiqh was divided into two elements, basically what we call usul and furu'. Usul represented the basic principles, usul from asl, which means root or foundation, and then furu', which means branches, represented, once you apply those foundations now, then how the principle that evolved from the application of the foundational concepts, that we call the furu'. Right? So each of the schools, depending on the usul that they worked from, developed different sets of furu'. And this is where this now contributed to more rigidity in the madhabs. Right? Also in this period, you had compilations of tafsir and grammar, Arabic grammar, developing. And the scholars, the students of the major scholars, their rulings, etc., are being recorded, and their students' rulings are being recorded. So you're having a huge compilation of rulings taking place. In this period, basically, 6, we could say, sources of Islamic law were recognized. But before looking at them, we should note that although the process of organization and classification of the rulings in terms of madhabs was fundamentally a positive trend, because to organize is good, to classify is good. However, with the court debates and the tendency towards factionalism, it became actually a factor in rigidity. So though by itself it was a good principle, it also contributed to the rigidity. And so you found then that terminological differences became the basis for major disagreements amongst the madhabs, where in fact when you looked at the root of the terminology, they were talking about the same thing, but just gave it different names. Later generations, the scholars came up with the phrase, La mashahata fil istilah. There should be no arguments in technical terms. We shouldn't argue about technical terms. We need to know what those terms meant. As long as they mean the same thing, then we should agree. We don't need to, because you chose one name, I've chosen another name, etc. Then it shouldn't be an issue. Now, if we look at the source of Islamic law, we see that the primary source is the Qur'an and the Sunnah, as developed from the time of the Prophet Muhammad. Added to that was the opinion of the Sahaba. This could be called ijma' in the case where the Sahaba agreed that became your principle of ijma. This is what they all agreed on. Beyond the time of the Sahaba, when the scholars differed. Some said yes, the ijma continued after the time, students of the Sahaba. Others said no, the people were too scattered by that time, the time of the Umayyads, etc. They were too scattered to establish ijma. But the opinion of the Sahaba, they looked at it from two perspectives. One, where they agreed, we call that ijma, and they said this would be sufficient to establish a rule. The other case where the Sahaba didn't agree, we had different opinions of the Sahaba, then they said these were just considered to be personal opinions, and scholars were free to choose whichever one they wished, or to choose their own. Choose from what they felt was more applicable. Right? The fourth principle is now qiyas. Qiyas being the method by which ijtihad was done. Scholars not finding anything in the Qur'an, Sunnah, or opinions of the Sahaba, were then required to deduce rulings themselves. This was done by way of qiyas, or analogical deduction, right? Analogical deduction, where you compare similarities and then apply rulings. So what you do is you look at a case, you have a case in front of you, and you want to come to a ruling concerning it. That case is not found in the Qur'an and the Sunnah. However, there's another case in the Qur'an and the Sunnah which has similarities with this one. So where the similarities are sufficient to say they are just variations of the same issue, then we can take the ruling applied to the one from the Qur'an and the Sunnah and apply it to the one which is not found in the Qur'an and the Sunnah. Now, of course, the degree to which these were similar will determine how accurate the transferal of the ruling is. Right? Because if you make a ruling on an apple and an orange because they're both round, right? You can find that the end result might be quite different. The apple's juice is sweet and the orange's juice is sour. But they were both round, right? So if you just assume because of the fact that they were both round, that's the common factor, and you said since the apple we know is sweet, we'll say therefore the orange must also be sweet since it's also round, you will have been wrong. Because the similarity of roundness was not sufficient, that was an external similarity, whereas internally they were different. So you have this, what they call qiyas ma'al fariq. That this is an analogy which contains in it a flaw. That there is in fact a difference, a sufficient difference to make the transferal of the ruling invalid. So this is the issue, this principle. This is where you found your biggest differences. When you look at where did the scholars differ, when you come in to look at the differences, we find that there were differences concerning the Quran in terms of interpretation of verses and what they meant, but they were small. In terms of the Sunnah and Hadith, there are differences. Would you accept this Hadith or not accept this? There are differences. Opinions of the Sahaba, where they agreed, ijma. Some differences, but very slight. But when you came to qiyas, this is now when you found big differences developing. Because scholars had different ways of looking at things. Where you saw a similarity, somebody else didn't see a similarity. So you will apply a ruling that they wouldn't. So this is where you find your greatest example of difference. But just as an example of qiyas in operation, where Prophet ﷺ had said every intoxicant is khamr, and every form of khamr is haram. Right? Though khamr was grape juice, we said, or any other kind of liquid, if one were to smoke something and get the same effect, then we say, we're looking at the effect, not the form. It's not the liquid. Also, potentially, they have some stories which are written, science fiction stories, where in the future, people will be able to connect the electrodes to your head, right? They're doing it now. And then they put an electrode inside the brain to your pleasure center, because there's a place in the brain which controls your feelings of pleasure. So now, if you're able to prod that area or give it a little shock, whatever, you get a feeling of pleasure. So now, if you then, get a little instrument where you just have a little button, you can press it, So anytime you feel down, you just press it. Eventually, you can get addicted to this thing, and you can be pressing this thing until you're no longer conscious of the world around you. So your brain has been blocked in that regard. So then you talk about something electronic, electrode in your head, but the end result is the same as a person who takes alcohol. They lost it. They're no longer conscious of what is around them, or marijuana, or heroin, or whatever. No longer conscious, the brain has been veiled. So even in this form, we say this is khamar. This is khamar. What is happening here, that process, is a process of intoxication. So we say that becomes haram, okay? By qiyas. Another principle which evolved was that qiyas, with its limitations and not being direct, sometimes may come up with conclusions which are not practical. They may come up with conclusions which are not practical, because the law is fundamentally text. Deduction may be valid and it may not be, and that's why you had all these differences. So it is not a sure method of arriving at the intended law in the Sharia. We can only say, Wallahu a'lam, Allah and Allah knows best. And that's what the scholars used to say when they made their ijtihads, right? Sahaba, etc. So what developed in all of the schools was a preference for what may be more practical. That a ruling which was deduced by qiyas may be impractical based on human need. So they will say, based on that human need, we will give precedence to it over the ruling that we deduce by qiyas. Now that was given different names in different schools of Islamic law. In the Hanafi school, it was called istihsan. In the Maliki school, it was called al-masalih al-mursala. In the Shafi'i school, it was called istishab. But all of them ended up doing the same thing. There's slight variations, but virtually they were the same thing, right? So we call this the principle of legal preference, where legal preference is given to a need over a ruling deduced by qiyas. For example, we have the statement of the Prophet ﷺ, whoever sells food should not do so until he has it in his own possession. Whoever sells food should not do so until he has it in his own possession. But we know that there are a number of circumstances where selling something you don't possess is a norm in the society. People pay for it before they receive it. You don't have it. You want to buy a boat. You tell the boat maker the size and everything else, and then you have to pay him. He hasn't made the boat yet. He doesn't have it in his possession, and he has sold it to you. So by qiyas, we'd say this is haram, not permissible. But by custom of people, what has been accepted as a norm in societies all around the world, this type of arrangement is acceptable, and precedence is given to human need, because that boat builder cannot go out and buy the materials unless he has the money. Right? In later times, when you had, boat building was reduced now to big companies as opposed to individual boat builders, then the company can have the kind of wealth to create the boats and set them up, and people come in a showroom and choose the boat they want. That's another circumstance. But in the early days, when each boat builder was a boat builder himself, he didn't have extra boats. You had to come, you pay him the money, he goes buy the material, and he makes your boat. So the need was that money be given in advance. So it was given precedence over the ruling deduced by qiyas. The last principle, which evolved in that period of time, was that of urf, or custom. Customary rulings, which is not a question of necessity now and need. Because one might say, what's the difference between customary rulings and istihsan? But we just spoke about legal precedence. If precedence or validity is given to urf, or the custom of the people, then what is the difference between that and istihsan? Istihsan, we said, was where you had a ruling by qiyas producing an untenable situation. And there is a need for an overrule. Then comes in your principle of legal preference. Whereas urf just deals with the common practice. No need here. Prophet Muhammad said you should give the mahar. Man should give the mahar to the woman. In Egypt, they developed a practice, and in other countries, where the mahar was divided into two parts, a muqaddam and a muakhar. You gave a certain amount in the beginning, and a delayed amount was saved in case of death or in case of divorce, that this other amount would have to be given. Now, this doesn't go against the Sharia, in the sense that the Sharia doesn't say it has to be all given at once. It could be delayed. If the wife agrees, it can be delayed. So this is a custom in a given area. And that custom was given validity and accepted in the legal system in those areas. Right? So this is an example of custom. And this is, of course, where the custom doesn't break any Islamic principles. Where the custom breaks a principle, it's rejected. It's not given any precedence. It's not given any validity. Islam rejects it. We talked about that before. We talked about how Islam enters into any given circumstance. That it doesn't come to destroy everything and replace it with new. What was good that which existed, it affirms. What was bad, it prohibits. What was workable, it modifies. So Islam is constructive. It's not destructive. So those were the main 6 principles. We'll just give a chance now for questions. We'll take some questions before doing our section summary. Okay.
Regarding this custom, now they are to be used only at the time of qiyas, or in general they can be used?
No. Brother's question, our customs, the customary practices, urf, are they to be applied in the case where qiyas is untenable, or are they applied generally? They are applied generally. Where they are in the case of untenable qiyas, then we have istihsan, or legal preference. They gave it another name. Okay?
Concerning the time of the hypothetical fiqh that you mentioned, and the books that have been written, why couldn't the reformers destroy all these books to avoid confusion amongst the ummah. If somebody opens up this book and he looks at it, I mean, that will cause a lot of confusion. So why did they not, before this time?
Okay, brother's question, why didn't the later scholar destroy these earlier books? Well, for one, these books were guarded, protected, became the source of the ultimate limits in madhab fanaticism, which didn't end until the 21st century. Right? Still alive, even till today, but on the scale where Hanafis couldn't marry Shafi'is and there's 4 prayers going around the Kaaba, that scale didn't end until the 21st century. So those books were protected. The scholars that arose from the tradition of Ahli Hadith down through the years, they rejected such rulings and they taught against them. But their focus was, again, constructive, not destructive. I mean, though me as an individual coming across a book like that, translated into English by Molvi so-and-so from India, I could advise them burn the book. But to go back to the Islamic library in Calcutta, where they've gathered a number of books they have I forgot the name of the museum that they have there. I visited it, and they have those books. For me to go and tell them, please burn these books, no. No, they're not going to say to burn it. No, because you see, this now becomes tradition. This is a part of the heritage. Heritage that perhaps one needs to learn from. You see, we may not use it anymore as a basis, but at the same time we can learn from how far people can go astray. You can learn from it in the negative sense, what to avoid. And also we have to consider that not everything in the books was in that category now. So though there was this body of, unnecessary, absurd fiqh, there was still a body of valid fiqh rulings which dealt with issues arising in their various times. So it was not totally, we can just say, no, burn the book. No, not totally. So we still retain it, recognize what is good from it, recognize the harm that developed, and understand the process. Why did this develop? What were the factors which led up to it? Further question? No? Okay, so we'll just summarize our main points. That what has taken place here in this period known as the flowering, and this is a long period, 200 years. I mean, although the period of decline which comes later, right, because we look at, or the period of consolidation coming in between that.
I have another question on this period. Is this the period that the non-Muslims tend to kind of hit the Muslims with, this is the time that Hadith was written, this is the time that Tafsir was not compiled, but they claim that this is the time when it was written? Is this the period that or is it after that? Or?
Okay, brother's question, whether this is the period that is usually identified as the time in which the Hadiths were compiled. They usually say 200 years after the time of the Prophet, right? And he died in 632. So 200 years later would have been 832. So yes, it is exactly in this period that they're referring to. This is the period of the great Imams, the latter part of the great Imams. The scholars of Hadith, Bukhari, and all these were in this period. So this is where they claim that the Hadiths were fabricated, invented. Anyway, as I said, fiqh took on a particular format in this period, distinguishing it from the other areas of Islamic learning and knowledge. It now evolves out of this era as a distinct area. Of course, but it wasn't that alone. Hadith as a science developed in this period too. Also tafsir, because in the earlier period it was all together. Scholars taught everything. Here now a certain amount of specialization is taking place. Also, there were many schools of Islamic law. In the period of flourishing, you had no end of schools. Wherever there was a scholar, there was a school. So you can imagine, there were many. Later on, we'll look at some of the major ones, but there were many others besides them. We look at about 13 or 14 of them. People only know the 4, but we are going to look at about 13 or 14. And there were many others besides them. We see that many centers of learning arose, of Islamic learning arose there. And fiqh began to be compiled systematically. Fiqh is divided by the scholars into 2 sections, furu' and usul, foundational principles, and the branches, application. And in this period also, we find in the early part a flexibility amongst the scholars, which was the tradition, the heritage of the earlier generation, and in the latter part, the beginnings of rigidity. So these are the main concepts developed in this chapter and this lesson, inshallah. So if there are no other questions, we'll close. سبحانك اللهم وبحمدك نشهد أن لا إله إلا أنت نستغفرك ونتوب إليك.